Okay. Um, all right. Now I'm gonna screen share. All right. So thank you everyone for joining us. I'm Leslie Sultan, estate planning attorney. I have my guests Kathy Barron and Suzanne Nitzberg with us. I will introduce them in a second. Just wanted to briefly say, thank you for coming out on a Wednesday evening and joining us to learn about beneficiary nightmares and what could go wrong. So we do appreciate you joining us, and we hope you'll have questions at the end. And we look forward to this presentation. So I will start by quickly introducing myself and then my guests. So I'm Leslie Sultan. I am an estate planning attorney. I'm also a mom with two children that are minors. I have a business that I founded in 2010, so I also have to think about how to protect my business. And I now have a law partner. We are San Martino and Sultan Law Group, and we take a personal approach to every case that we work on. So I just always like to throw that out there. My two guests, first is Suzanne Nitzberg. She is a certified financial planner with 40 years of experience in the New York financial services industry. She's known for providing thoughtful, personalized financial guidance grounded in comprehensive need-based planning approach. So we're super lucky to have her here. And I
Thank you.
also have Kathy Barron. She is a life insurance specialist with 12 years of experience at Allstate Insurance. She's helps clients find practical, affordable life insurance solutions tailored to their needs. Her goal is to provide clarity, guidance, and lasting peace of mind. She makes the process simple and stress-free so you can feel confident about the future. So thank you both for coming.
Thank you for having us.
Sure.
Yep, thank you.
So, and I invited them because I'm an estate planning attorney. I deal with obviously, what can go wrong without an estate plan or with a bad estate plan, but also they have a tremendous amount of experience seeing what could go wrong when naming beneficiaries on life insurance or on bank accounts or retirement accounts. So I'm very excited to hear their stories, to learn from what they've seen as, professionals in this field, and how we can all learn from those stories. So quick disclaimer, we are a part of this is legal, law office presentation, but the materials here is for informational purposes. It does not constitute legal advice. You should not take any action based on this information without consulting a legal attorney, a real attorney, and nothing can be taken as engaging or offering to engage in any activities as an attorney-client relationship. So, but hopefully we're going to give you some great information. So, number one, anybody here named a minor as a beneficiary on a bank account or life insurance? So going right into it, this is the first thing you do not want to do. And I know Kathy is anxious to tell us her story, so I think you should take it away, Kathy.
Okay, so yeah, you definitely never want to do that. And if you name a minor as a beneficiary, that's a very, very bad thing unless you name a second guardian for that policy. So I had a story. There was a 14-year-old child who inherited quite a decent amount of money from his grandmother as a life insurance policy, and it wasn't allowed to go to him directly. We are on Long Island. I don't know where everyone else is from, but on Long Island, this was on Long Island. The money had to be deposited until he was 18 in a very, very low interest bearing account in a Long Island bank that was mandatory to put in there for the courts. So basically, he gave nothing in 4 years. It was a waste, but there was no choice. Had there been a beneficiary, had he not been a minor, the minor wasn't named a beneficiary, this would have been a totally different story. At least he could have earned interest and, or invested it or done something. We could have done something else with it. So terrible story, but, that's just something that people have to realize if they have minor children. So.
And just to add to that, Kathy, do you have any idea what did it cost in terms of legal fees just to get that set up?
Oh, uh, about $15,000.
$15,000, right?
Mm.
So a parent, another parent or a guardian had to pay legal fees in order
Because
for the minor.
the
Mhm.
parents had they had to do a 40 or 30-year background check on the parents. It was a whole, even to even let the parents have anything to do with it, which the parents couldn't take the money out anyway.
Right,
But it was a whole thing that the attorneys had to do just to even get the parents appointed as like the guardians of that the account. Crazy, crazy.
right, right.
So.
Yeah, and I can get into the legalities, but Suzanne, do you have a similar story that you'd like to share?
Yeah, I think that most beneficiary disasters can be prevented if we as financial professionals, ask questions. Just, when was the last time you reviewed your beneficiaries? Because it's not something that everyone thinks about. You fill it out 10, 20 years ago, and then you never update it. You can, for instance, I had one pretty recently that became pretty heated. A client remarried, and he updated his will, leaving everything to his new wife, but he never updated his 401k beneficiary form. So, and it still listed his ex-wife. He died, and the plan admitted, it was a big, big mess. They tried to draw me in. It was a horrible situation. And so, goes according to the beneficiary form,
Right,
right? I mean, there are things you can do to try and prevent that from happening. But so the new wife, lost the entire account, and you just have to keep in mind there are different events that whether it be marriage, divorce, birth of a child, death of a, there are a lot of life, things that
changes.
happen in
Yeah,
life, and that we should always be thinking about that, um, and that's where you help me.
right.
You keep me in line.
Yeah, right. Yeah. Yeah, so thanks for sharing that. So yeah, so just to reiterate, so anybody under 18 cannot legally fill out the beneficiary claim form, right? They can't, a 5-year-old cannot fill out a claim form and submit it to the life insurance to receive the money. So what has to happen legally is when there's a life insurance or a retirement or something and the beneficiary is named, it has to basically go through the courts, and somebody on behalf of the minor has to petition to be the guardian of the property for that minor. And unfortunately, that is a full legal process. It requires
Right.
filing fees with the court. You don't necessarily have to hire a lawyer, but it's usually done more efficiently because lawyers know how to do it. And as Kathy said, the courts aren't going to allow that money to be invested aggressively, right, and grow it because there's risk. And the courts can't be held responsible. What if they put, $10,000 in an account and it drops down to eight? The court could be held liable for the loss to the minors, so they'd rather it grow just a tiny bit. And for financial planners, this is a nightmare. And then, Kathy, when the child turned 18, did they automatically get their money?
Oh no, the parents had to petition the courts again. And it was a whole nother, all this paperwork that was involved. So it took another probably 6 months even just to get the money out of that bank. And when you talk about investing, they wouldn't even, which is a shame. I mean, there must be something with this bank because it's the only bank you can go to, but they wouldn't even let them put it in like say a CD, which is completely safe.
Right.
It's not even like at least you could have gotten some form of interest, at least even if it's 2% versus 0.000 whatever,
Yeah.
So
Yeah.
that's
But
just
Kathy, you were saying that they put it in an account. Wouldn't they put it in a trust since it was a minor?
no, it was custodial, it was a custodial account. It was I forgot the way
Oh,
it was
okay.
worked. It was a custodial account, but the parents there was no way the parents could tell you could not withdraw from it at
Right.
all.
Right.
So you had to
But
wait till he was 18 and then it was a whole another more legal paperwork and that sort of thing just to even get it out.
That makes sense.
right,
Well,
But it
but
to
was
the
a
just say
state
one
nightmare. It was a
can.
thing,
nightmare.
Leslie,
Yeah.
and naming one, other thing that I've ran into a lot, I started thinking about it since we spoke last, is that naming one beneficiary isn't enough. When the primary beneficiary dies and you forget to name a contingent beneficiary, that's a big problem too.
Yeah.
So, you have to have multiple beneficiaries because when one dies, no one thinks about that.
Right. So I made one slide for each of these topics, so I'm going to get to
Oh,
that.
you did. Okay, I'm sorry.
Yeah, so just on the minors, and Melissa, that's a really good point. So the child cannot make his or her own trust, but to avoid this problem, right? Because my goal is to help everyone understand how could this have been avoided? The parents or the grantor, whoever named this person as a beneficiary, grandma, whatever it is, can create a trust when there's minors and name the trust as the beneficiary. And that would allow the trustee to fill out the claim form, receive the money to the trust, and then hold the money until the child is whatever, 18, 21. You can get very creative with the ages. Default is 18, but you can change it 21, 25, 30, whatever you want, and then distribute the money at that time. And all of that would have avoided the courts.
That's what I'm thinking the grandmother would have done.
Right. So, right. In an ideal scenario, somebody who has minors that they want to leave as beneficiaries, instead of leaving the beneficiaries as minors, they would create a trust, name the children as beneficiaries in the trust, and then list the trust as the beneficiary on the life insurance. So it sounds like that wasn't done in this instance, unfortunately. I'll just add that the other thing I've seen a lot of people do is they try to get creative and they'll say, well, I do have a minor. I don't really want to do a trust for, it's too expensive, or I don't have enough assets. So I'm going to name my sister. And my sister, I know, will take care of my children. And she probably would. But what happens if sister dies? What happens if sister gets sued, right? So it can get very complicated with unintended consequences when we try to name anybody to manage it for the minor. The real solution is really, guys, setting up a trust. So you guys brought up a bunch of other ones, so let's get into some of the other ones and then we can circle back. So as Suzanne said, contingent beneficiaries. So you don't just want to name the one, because what if that person dies? You want to have successor beneficiaries, or what we call contingent beneficiaries. And I'll explain the difference between per capita and per stirpes, because you can say that on your beneficiary listing. But anything you guys also wanted to add with regards to adding contingent beneficiaries? Okay, so per stirpes is Latin for of the tree, of the roots. So like if you imagine a tree, the branches, I think it's per the branches. Sorry, my Latin's off today. Your children, right? So your children, your grandchildren, anybody by blood. So not a spouse, because that's not by blood, but whoever is in the family line would inherit. So I could say I leave everything to Kathy per stirpes, and that language indicates that if Kathy dies, it automatically goes to her children, and if her children aren't alive, to her grandchildren. Now, there's also a designation for per capita. And sometimes this is a box you could check, but per capita is per head. So that means, like, if I'm naming Kathy, it's only for Kathy. And then if I put Suzanne second, it's only Suzanne. It doesn't automatically go to those children. So just so we're, educating people, the difference between per capita and per stirpes. Per stirpes goes down the bloodline. Per capita is like per the person named only. So in some cases, you can just put Kathy Barron per stirpes, and they would know to provide proof of her children, and then her children would inherit. But we like to just list it out if you can, to Kathy, if not Kathy, to her son Joe, if no Joe, etc. So that's contingent beneficiaries. Go ahead. Someone have something or no? Okay. All right, moving on to the next one. Another one Suzanne mentioned is divorce, right? So divorce is super important when it comes to naming beneficiaries. Do you guys have anything else you wanted to share on the divorce end? Okay.
I think she shared it before by accident. She just
all right, no more out of turn sharing. Okay.
Yeah.
So one thing to know about New York specifically, I don't know about a lot of other states, but So while you're in a divorce, you cannot change your beneficiaries. Okay, so there's something called automatic orders that technically freezes your standing, and you're not allowed to change your beneficiaries. As much as you hate your soon-to-be ex-spouse, you cannot change them without a stipulation or a court order that says so. And then immediately, once that divorce is final, however many years it takes, once it's signed by a judge and entered and then final, that automatically revokes the spouse as the beneficiary. However, and I suspect this is what happened in Suzanne's case, not if it's a federal account, like what is it, ERISA or
ERISA
yeah.
plan, right?
So an ERISA plan is if someone's a federal government employee,
Yes.
they're getting a federal plan. Federal government does not acknowledge a measly little state order. Okay, and so that's where the problem lies, and we've seen this a couple times, unfortunately. If it's a local plan or a state plan or whatever, they have to acknowledge
Right.
the order. But the federal government
Federal versus state is always a problem.
we're not going to acknowledge that. Why didn't they
Right.
change? If they wanted to change the beneficiary, they should have changed the beneficiary. So, real important, if you know anybody who recently got divorced, is in the process of getting divorced, once the divorce is final, they can change the beneficiary. They have to change the beneficiary because otherwise there's nobody named. It's going to be automatically revoked and there's nobody named. In some cases, I've seen, I don't know why, people want their spouse, their ex-spouse, to be the beneficiary. If that's true, you literally have to go back and add them after the divorce. So this is
Why
something
would anyone want that?
I don't know. I can only think of it when there's minor children and it's an amicable resolution,
Okay.
right? And especially if you're a federal employee with a federal retirement plan, you 100% have to go and change that after the divorce. All right. And not always during the divorce. Now, you can do it during the divorce with a settlement agreement, with an agreement that both parties are agreeing to this. Okay, so if you're in the middle of a divorce, make sure you're speaking to your attorneys and get it done properly. All right. So another great example of beneficiary nightmares is when you name someone who's receiving a government benefit. And this is a big one that most people don't
Forgot
think
about this. Yeah.
Okay.
Leslie, I have a question. Are you taking questions right now, Leslie? Or are you
Sure.
going to wait till you get to the end?
Go ahead,
All
Stanley.
right, so my name is Stanley. Thank you. I have a question concerning naming a relative and then their bloodline as beneficiary. Now, if that beneficiary, let's say my sister and she has kids, she passes away, wouldn't her children now face those same problems as we talking about naming minors?
Yes.
And you'll address that later, I'm sure.
I mean, I would say it's the same setup. So if your intention is for your sister, and if your sister were to pass to your nieces and nephews, then you might want to consider a trust instead. Obviously we wish you a long life and your sister a long life, but in case something were to happen, you would be having that problem. Right. And the other problem, of course, is even if they're close to 18, and let's just say it's $1 million policy. Do we really want an 18-year-old receiving $1 million policy with no mom and no uncle, no great uncle to be there? So you might want to consider the trust, because you can name in the trust, my sister's my beneficiary. If no, my sister, then her kids, and we hold the money until they're 25, 30, 35.
Okay, sounds good.
Okay, great.
Thank you.
Yeah, you're welcome. Thanks for asking. Okay, so nightmare could go wrong so what do you guys think happens if you are a beneficiary and then all of a sudden you're receive a big chunk of money in your bank account and you're also a recipient of some kind of government benefits? What do you think could go wrong?
You don't get the benefits.
Right. You lose your benefits.
And I would say that Medicaid or whoever it is, they find out, they take it all.
Okay, right. So in a situation with its Medicaid, they can take it. If it's disability, sometimes you lose the disability. Obviously, all of these are extremely unintended, right? And so we do not want that. In some cases, like we've seen in a personal injury case, for example, there's an award and the person all of a sudden gets a bunch of money. The attorney forgot to ask, are you on any government benefits? Gives them a bunch of check. They lose their disability. Now we can create a trust for them. And then once the money's out of their name and into the trust, they can reapply for disability. But like Melissa said, you can't get your money back from Medicaid, right? They're owed that money, so to speak. So, if there's a potential for somebody that you care about to receive, then you definitely want to consider setting up a trust. So that the trust again is named as the beneficiary. The trust would then receive the money for them. It would not ever give the money to them directly, but it could buy things for them. It can pay their rent. It could buy them a house. It could pay their travel. There's a lot of options there. But the point is that it would not prevent, it would avoid them losing their government benefits or having the government take the benefits. Any questions on that or anything anyone wants to share on that?
I would say it's always good to put money into a trust.
So ideally the beneficiary would be the trust, right?
Yeah.
Yeah. So you'd have to create, that's a good point. So you have to create the trust first, name the trust as the beneficiary, and that would avoid all the complications
Right.
with the government benefits.
Yeah.
Yeah. I mean, we can do the trust later in some cases, but it's obviously not the right and best way to do it.
Yeah, I would say do it first to avoid the headache.
Yes.
Yeah, definitely.
Mm-hmm. All right, let's see what else we have in the nightmare. All right. Buy-sell agreements. So I don't know if anybody on here is in a business with a buy-sell agreement. I don't know, Kathy or Suzanne, if you guys want to touch on this.
Yeah, I had sent you something about that. A lot of business owners like to do this so that, the partner's business can be bought out, when one partner dies. And so what happens is, they each have a life insurance policy on the other. But what happens is if you don't set up if you buy the life insurance and you never set up the agreement with an attorney, then it all goes to hell because you're going to end up being in business with your partner's, late wife, with your late partner's wife. So it's important when, putting together a buy-sell plan, which is a little more complicated for businesses, but it's important to follow through and meet with an attorney and do the whole package, not do it piecemeal, so that the intended owners of the business remain after one business partner passes.
Yeah, that's a great one. So I'll just jump in. Buy sell is, if one of the business owners dies, if there's life insurance, the beneficiary is supposed to be the other partner, and the intention is to buy the business interest from the deceased partner.
Right.
And usually that's done through a legal contract.
Right.
And this is the scenario Suzanne is talking about where they bought the insurance and didn't have the contract. So the wife was like, well, I'm keeping the money and I'm in the business. I don't have any obligation to do anything. So it reminds me of, has anybody heard of the Bob Ross story or seen the Bob Ross documentary, the painter Bob Ross?
Oh, yes. Yes.
Yes. It was kind of a similar scenario where he, he had a business partner, they did well in the business, but then they had a kind of a falling out, and Bob Ross ran to his estate planning attorney and he created a trust and he said, I would leave everything to my son. And he died. And unfortunately, the business was governed by a business plan, a business agreement. And that was not transferred to the trust. The partners would have had to sign off on it. And, unfortunately, the son did not inherit the business and only got like the house. Right.
Terrible.
So, so hopefully everyone takes away from this that if you are in a business and you're doing a buy sell, or hopefully if you have a business, you definitely work with a business attorney to have those documents in place. All right. I don't know if anybody's seen this. I think this is not so common, but I do remember a few times I've seen the for example, if there's a minor, or oh, I don't know who to put, or whatever it is, the life insurance or whatever agent would say, oh, just write the estate.
Yes.
That means it goes to your estate. Well, that's true. It would go to the estate, and the estate is governed by, so anything in my name when I die goes to my estate. Who inherits the estate? It's governed by the law of the state that you live in. So in New York, it would go to my husband if I'm married. If I'm not married and I have kids, to my kids. If I have kids and a husband, it's 50-50. If neither of those, it would go to my parents. If no parents, to my siblings. If no siblings, to my niece and nephews, and it goes on and on and on. The problem when you name an estate is you have to go through court to validate who is entitled. And as Kathy mentioned, did we lose Kathy? I don't see her on here.
But
Oh no, she's there. Okay. Hi. You moved down on my screen for some reason.
oh, no, I'm here.
We've seen, that can get very expensive. What I like to warn people about is probate's expensive. It costs money, and it's extremely delayed in New York City.
Yeah, I want to just chime in about a second when you're talking about probate. Whoever's on this and is considering to do an estate versus a will, an estate is 100% the way to go.
You mean a trust?
This was a personal situation that I had, that when my parents had passed away, they had some things in a trust, they didn't finish it, and the stuff that was just in their will and the stuff that went through the trust was passed like nothing. It was so easy. Stuff that was just in their will took months and months and a ton of money in attorney's fees. So think about that when somebody tells you, oh, let's say it's whatever thousands of dollars to do an estate. Well, you know what? That will save.
Do a trust. Right.
A trust, sorry. It will save your beneficiaries like thousands and thousands and thousands of dollars. So that's my so.
Yeah, thank you for sharing that. Yeah, and I mean, and it's not just the cost of the court and the lawyer, right? Because I've seen, for example, co-ops, right? Co-op owners, for whatever reason, they don't have their co-op in a trust, so the co-op's in probate, and it could take 6 months. Well, what else is accruing during those 6 months? Maintenance fees,
right, taxes,
potentially mortgage.
Right.
Yep.
So now all of a sudden, all that stuff's owed once you get control of the estate. But now we just lost $10,000 in extra costs because of the delays.
Yes.
So
is it still like that with the co-ops?
So every co-op is different. Some allow a trust, some don't. And so every time we get a co-op, we say first thing you got to do is talk to your board.
Right.
A lot more have gotten hip to the idea that trusts are a great option, and so a lot more are allowing, but we still see some that say no. Yeah.
We had that situation with me that said no.
Yeah.
You remember that?
Yeah.
Excuse me, sorry. I have a question. Sorry, my name is Andy Jimenez. I'm Jeffrey Durant's cousin.
Hi.
Hi. Yeah, so I live in Hamburg, New York, which is basically Western New York, up here like by Buffalo. Is the trust laws in the city the same as the state, or this just applies to the city? Because I know there are some laws that are different, state and city.
Yeah, that's a great question, Andy. So I would say the trust works the same way throughout the state. The difference, though, is how long does probate take in your jurisdiction, in your county? So I've met like attorneys that do estate planning way up north, like up by, what is it, Vermont or Canada. I ask them, how long does probate take in your town? And they say, oh, a couple weeks. Here in New York City, the Bronx, it takes a year. Nassau, Suffolk is 6 to 9 months. So it really just depends on, the population and how many clerks are in the courthouse,
Got it. Yeah. I'm located in Erie County.
Okay. So I'm going to guess it's better than here, but it doesn't change the fact that if your minors are intended beneficiaries, they're going to have to go through the court process. Now, it might be a shorter process, but the fees are going to be the same. And the outcome is the same, that they have to have what's called a custodial account set up for them. They would have to petition when they turn 18 for the release of the funds. So it all kind of depends on your specific, what your wishes are and who your intended beneficiaries are. So
Yeah,
you might have.
my
Mhm.
scenario would be my wife and my two children. I got like a 2-month-year-old and a 5-year-old, and then my spouse.
Right. So assuming that you and your spouse passed away together or around the same time, neither one of them, your children, could could fill out a beneficiary form. They can't go through probate themselves. So somebody, a sister, brothers, in-law, whatever, would have to petition the court to be the guardian of their inheritance and then go through that awful process with the courts. So the process might be a little faster, but the outcome would be the same. So I would
So
probably,
sorry. So if I do the trust, then it would be, let's say, us four, but then I would have to add a legal guardian in case we both pass away, basically, right? Is that
right.
correct?
So specifically, you would name a guardian to raise the children, like as the legal guardian, making decisions for them, and then a trustee to manage the money. And it can be the same person, or you could separate it. So you might say, my sister is the best aunt in the world, and she's going to raise the kids exactly what I want, but she's terrible with money. What do I do?
Yeah,
So you
that's a good point.
pick my best friend who's not so great with kids, but real good with money. He's the trustee while sister's raising the kids, and she just asks him for the money and he writes the checks.
Got it. Okay, that makes total sense. Thank you so much.
Yeah, you got it. Thanks for asking. Um,
Hmm.
So on the estate side, the other thing I want to tell people, and most people don't realize this either, is probate court is set up for creditors. It's not set up for family. Family comes last. So literally everybody has to be paid that's owed money before the family can inherit. So the funeral parlor has to get paid. If there's credit card debts, if there's a hospital bill, all of those people come first. They make their claims, they get paid, and then the family gets what's left. A trust doesn't have that requirement. So another thing to think about, if you're naming the estate, you're literally setting up your loved ones to go to court and battle with creditors to see who gets their inheritance first. So, and of course, there could be something called penalties when there's certain types of retirement accounts. They have nowadays, I think it's a 5-year or 10-year, maybe Suzanne, you can correct me, withdrawal period.
It depends if it's a non-spouse or spouse,
Okay.
right?
So,
But it's 10 years.
10 years. So they don't want you to take all the money out essentially right when you inherit it. They want to pay it over 10 years.
Right. And most people I think are under the impression that as long as they get it all out by the end of the 10 years, they're okay. But that's not true. You have to take it out every year.
Okay. Oh, that's what it is. You have to take it out,
Yeah.
right? And then if you try to take it all out at once, there's a penalty.
Well, it could just put you in a higher tax bracket. You could always
Okay.
take it out sooner,
Okay.
but it could put you in the next tax bracket as opposed to taking it out over 10 years.
Got it. Okay. So thank you for clarifying that. That's why we need the professionals on here. So again, that can be avoided, with proper planning. So if you have a financial planner, you really want to talk these things out. Okay, I have this retirement plan. I'm going to name my beneficiaries. How does this work? How do they get it? What's the best strategy for them? If you don't have a financial planner, you're definitely going to want to reach out to Suzanne because and we got in this conversation because she's seen some bad scenarios that other people were set up with, and people came to her to kind of fix them. So we will make sure to have their contact. Maybe if you guys, while we're chatting, if you guys want to put your contact information in the chat.
Sure.
And but otherwise, we'll probably send it in some follow-up emails after the event. Okay, so and the next one is a will, right? We've kind of talked about this. You can always do a will and name beneficiaries in your will. A lot of people do this. What most people don't realize is that a will has to be probated. Nobody can take the will to the bank. and say, give me my money. The bank says, how do we know this is a real will? How do we know the person's dead? How do we know this isn't fraudulent? It has to go through court. The court issues something called letters testamentary or letters of administration, and that's what allows the representative to take over. So definitely, I just realized you guys, your messages are coming in private, so I'm gonna have to copy over.
Oh, is it?
I think it's the way this is set up. So I'm gonna put it
Oh.
here in the chat. No problem. I'll do it now. Oh, kitty. So a will can work, you know, and a lot of people do wills, but I just like to always, when I get a chance, educate people. Wills have to go through probate. And that's kind of what we were talking about with Andy and earlier. Then you know, it has to go through the probate process. Now, if you've named a beneficiary on an account and you say, okay, my checking account, my savings account, my life insurance all goes to Jane, but my will, I want everything to go to Joe, who gets it? What wins, the will or the beneficiaries on the accounts?
Beneficiaries.
Yeah. So beneficiaries trump a will. And unfortunately, we've seen this where someone says in their will, I want everything divided equally to my children, but then for some reason they only named one child as a beneficiary, or they have a joint account with a child, right? Okay, well, my daughter's helping take care of me. I'm going to put her as a joint account owner. But my intention is for my kids to split the money. Well, when mom dies, if there's a joint account owner, it's only going to that joint account owner. It's not going to go to the will because there's another owner. So you got to really, you know, kind of inventory. What are my assets? Who are the beneficiaries? And what's my intentions? Because they don't always match up. And we've seen, unfortunately, really negative outcomes by not doing this kind of comprehensive plan to make sure everything's correct.
And you know, and most people don't know about any of this until they start researching or until they hear
They learn the hard
from their
way,
friends or their
unfortunately.
family.
Yeah.
Like when they hear bad
Right.
stories, that's when people say, wait a minute, what do I have and what do I need?
Right.
You don't even think about it. You don't think about it until something happens. And then, you know,
Yeah, exactly. Yeah, I mean, we had a terrible situation where a guy, a father, had named his brothers as beneficiaries on all his accounts. And over the years, he wound up adopting a young child, and just totally forgot to update his beneficiaries on his account. And he did a will, and he said, "I leave everything to my adopted daughter." And he thought he did everything right, except he never went back and changed the beneficiaries. And it doesn't matter when the will was written, if that was his intentions. They trump. The beneficiaries trump the will. The will can only control what's in your estate. What's in your estate is what's in your name without any beneficiary or joint owner. All right. Pop quiz, guys. All right. I kind of just did this one. But a will says I leave everything equally to my 3 children. And then the beneficiary on an IRA says lists only one child. So who wants to take a guess? What's the results?
The one child gets everything.
Yeah.
So
Unless maybe
You've been
there's another
listening.
account.
He's been paying attention.
Yep.
Good job. Yeah, all right. That was to make sure we're all awake here. All right, so the other thing, obviously, and I think Suzanne mentioned this, is you've got to update your accounts regularly. I met someone the other day and she says, every January I check my beneficiaries and I update them. I was like, well,
I actually have
great.
people, but I also have run into, you know, I'm doing this a long time, people that update them too often. Every time they have an argument after the weekend, they're calling in. I gotta send you my new form.
That's funny. Yeah. Yeah. And then if you don't go back later and you make up with the person, oh gosh. Yeah. So, you know, that's a personal choice. You're going to have to decide how often. But the most important thing is you're checking regularly. You know, some people do it once and they never check again. That's obviously not what we want to avoid. There was a lot of stories during 9/11 where the firemen, they get a pension and they have plans. And when they started in the force, they named their parents, and then they wound up getting married and having children and never updated. And so the parents were receiving the benefits instead of the
Right.
spouses and children.
Yeah.
Yeah, so that's, the best advice we can give on that. So thank you. This is my contact information. I believe the QR code goes to a Google review link. So if you liked this presentation and you want to scan it real quick and give us a Google review, we would appreciate that. It helps let other people know, how we did. But otherwise, we will take some Q&A for a few minutes. And then at some point, I'll turn off the recording in case anybody has some questions that they want to do off camera, off recording. And thank you guys, Suzanne and Kathy, so much for coming on and giving us your time this evening. We really appreciate
Thank you for inviting us.
Yeah, thank you for inviting us. We enjoyed it.
Thank you, ladies. Sam, I do have a first question.
Sure.
It concerns TSP beneficiaries. If I pass, my wife passed, my two children over 18, again, the best thing, probably know the answer already after listening to you, great ladies. Again, the best thing there would be to list that in a trust also for the wife and the two children, well, two young adults.
Yeah, so again, so the question, if your children are already over 18, then we're not necessarily concerned with the whole custodial account issue.
I'm looking at taxes. I'm looking at taxes in the future for them to being it's a tradition. So when will they be able to draw from that in case of my death and wife's death?
So, okay, so there's lots of different types of taxes, but in New York, assuming you're in New York, there's no inheritance tax yet. There is something called an estate tax. So the estate has to pay a tax only if your total estate is $7 million or more.
I'm just shy. I'm good then.
Okay. So you'd probably, and then federally, just so you know, it's 15 million. So if you have 15 million, you're getting taxed at the federal and the state level. If state level, then you're going to want to consider more advanced estate planning that can plan for paying the tax so that your children can receive the inheritance. So it gets a little bit more complicated, but just to give you an example, we have something called an ILIT, which is a life insurance trust. And so the best way that works is we create a trust. The life insurance goes to the trust, and then the life insurance pays the tax. Okay, so to break it down a little bit, if your estate is worth $10 million, the tax could be $3 million, but you could get a life insurance policy for $200,000. And then when you die, all you've paid is $200,000. That life insurance pays the $3 million, and your children inherit the full $10 million estate. I think I explained that right. Okay, so that just kind of gives you an idea of how to do estate tax planning.
Inheritance tax, does that includes in this case, if we do a trust, there wouldn't be no inheritance, right? It would just be passed to the beneficiary, right? Is that correct?
Right. So there's no inheritance tax in New York. New Jersey has an inheritance tax, but I don't do New Jersey inheritance stuff.
Yeah.
So, but the estate tax, so we're different. If your estate is less than 7 million, or if you're married, it doubles. You don't have to worry about an estate tax. So, for example, my mom died last year. She had less than all of that. And so me and her brother received everything 100%. There was no tax.
Okay. But she had an estate.
My mom had a trust.
A trust. Okay.
Yeah.
Okay.
Thank goodness.
That's what I just wanted to clarify. Okay.
Yeah.
Cool.
So whether there's a trust or an estate, what we avoided was probate. and all the delays. And literally all I had to do when my mom passed is just write a check to her brother and write a check to myself because
Oh,
everything was
okay.
in the trust while she was alive. If she didn't have a trust, then I would have to go through probate, get appointed, and then marshal, find all her assets, put them into an
Right.
estate bank account, and then distribute it.
But because you were the beneficiary and your mom passed away and she was part of the trust, because she passed away, did you have to close the trust? Or if you wanted, like, let's say there was a couple of multiple houses or rental properties in this trust, right? Can you leave the trust open with the benefit? Like, let's say my mom opens a trust, we have a couple of rental properties, and it's me, my brother, and I, and my mom. Right, my mom passed away. We can continue the trust as is.
Exactly. Yeah. So, and that's a great example, Andy, because hopefully when you have tenants and you have these investment properties,
Hmm.
mom's creating an LLC so that she's
Haha,
limiting
yes.
her liability. But
Hmm.
here's the trick. When you create an LLC, now it's a private entity. And
Hmm.
when mom dies, nobody can manage a private entity because mom was the only owner or member.
Hmm.
But she can transfer her membership or ownership to the trust, and then the
Yes.
trustees can immediately take over. So that's a perfect example of how to protect investment properties. Put them in the LLCs, put the LLCs in the trust, and then the trustees can immediately take over. And it's such a benefit.
It,
So it
and that's
so if
exactly
my
what happened to
mom.
me.
Mhm.
So when she's saying that, exactly what happened to me. My
Okay.
parents owned properties, and it was all in it was in an LLC, and the LLC was in the trust. It
Hmm.
was like immediate. It was like there was no work, no nothing to do with that whatsoever.
Yep.
What here's a question. What do you think about S corporations? And I used to have an LLC before, but
Yeah.
somebody was telling me also that an S corporation is also a good option. But what would you think in terms of tax purposes?
So I'm a lawyer, I'm not an accountant. So I always say
Hmm.
tax questions have to go to accountants. For legal purposes,
Hmm.
they provide the same liability protection. So
Okay,
as
yes, that
an
was the other
attorney, it
question.
doesn't matter to me whether it's an S corp or an LLC. They're shielding the individual from liability
Hmm.
from the tenants because tenants are
Okay.
liability. They get injured, their friends get injured, they sue the owner. If it's owner's you, they're coming after your assets. If the owner is a corporation, they can only go after that one asset.
And what if
So
the S corporation or the LLC is under the trust? Can go after the stuff in the trust or just
correct,
whatever's okay,
correct.
whatever's in the S corporation, that's the gap.
Correct. Yeah. So
Oh,
the
that's fine.
question for whether it's an S corp or an LLC is going to depend on how much income is generated and how you want it to be taxed.
Got it. Thank you so much.
Yeah. No, these are great
So,
questions.
Leslie,
Yeah.
I have a question. I have a family trust naming my two adult children as beneficiaries, but now I have a grandchild and I anticipate I may have more grandchildren in the future. Should I
Congrats.
name them as beneficiaries or just create a stipulation that my children have to use some of their inheritance for my grandchildren?
Great question. So it
Yeah.
depends on your intentions, right? So if your intention is, okay, I have $100,000 and I want my kids to split 50,000 each, and then no, that's not gonna work. I want 50% to go to my kids and 50% divided amongst the grandkids, then you probably have to change the trust. But if it's your
Yeah.
intention that while my kids are alive, everything goes to my kids, and only if one of my kids dies does it pass down to the grandkids, you probably don't because we probably have language that says that already. It'll say to my
Well,
children per stirpes, or if one of my children dies to their children. So it depends on what your intentions are. So if your intention is to reduce their share to give to the grandkids, probably you would have to change it.
Okay, but would I name my grandchildren as beneficiaries?
Yeah,
Because then who controls that money then? I mean, like
right.
my granddaughter was just born 6 months ago,
Oh,
so
congratulations.
thank
Yeah.
you.
Right. So whoever is the then acting trustee would control it. So I'm assuming you appointed someone to act as trustee when you
Yes.
pass away. That person would be then maintaining it for the benefit of the kids until they reach whatever age you decide.
Okay. But is that the best way to do it? Just leave it as to name the grandchildren as trustees and then have someone else manage have the
Yeah, so you would name,
Name
so
them as
the,
beneficiaries, I'm sorry,
right,
and have
yeah.
a trustee then manage it.
If it's your intention to split up the assets so that, because you don't want your children to spend all the money and then there's nothing
Exactly,
for the
that's it. I don't
grandchildren.
want them to spend all the money.
Yes. And I remember when my grandfather died, I received like $6,000 or something, and it was great. I felt considered. My grandpa thought of me, and I used it to buy my first car. So it
Yeah,
makes
well,
a
I'm thinking
difference.
more like, how much is college going to spend cost in
Right.
another 18 years? I'm trying to like make it so that they'll have some money if they want to go to college.
Right. Exactly. Yep. Yeah. So if your intention is to leave them specifically money, then you have to name them specifically in the trust.
Okay.
Yeah. And we would do that way. You would do that is through an amendment. And so you do an amendment to the trust, and we're saying we hereby modify the distribution as follows. And then that new amendment would govern the distributions.
Okay.
Yeah, great question. Thanks, Ellen.
Yeah.
I've got another one for you if you really want to get into it.
I think
My husband
someone
and I have been
Go ahead.
separated for a long time. We are not divorced. Now, I
Mhm.
don't know how that figures into this whole thing. Does he have any claim on my, like, I put money, I'm leaving pretty much everything to my children as beneficiaries or through the trust.
Yeah.
Trust. So
So
can
technically,
he like get in there somehow? Because I don't think he will, because we've been very
yeah.
amicably separated. But
So what we like to do is have the spouse sign what's called a waiver of the spousal
I
right of
think he did
election.
sign one when we did the trust. I believe he did sign a waiver.
Okay, so if he
Yeah.
signed a waiver, then he's saying I have no right to anything in her trust. If he
Okay.
didn't sign a waiver, then you have the potential that he's going to say, I'm entitled to 1/3. Just because you wrote me out doesn't mean I don't get my share.
Yeah,
Give me
no,
my
I don't. I
money.
think he did because, like I said, he doesn't really want anything from me. But you
Okay.
never know; they might change their minds.
Yeah, or he could get married and then
You
she's
never
going to
know.
try.
That
Oh, no,
new
no, she can't.
wife.
Yeah.
Well, he can't get married until he divorces me.
You're
Oh,
right.
that's
You're right.
right.
Yeah.
Well,
You're right.
right.
Right. But you never know. The
Right.
fiance or whatever. Yeah.
Yeah,
You never
that's
know.
funny.
Yeah.
Yeah, I think we've got the longest separation in history. So,
That's hysterical. Hysterical.
Yeah. Hopefully he dies first. No offense, but then you could get whatever
yes,
he
and
has.
that'll solve the whole problem.
There you go.
Whatever works, right?
Unfortunately, he's in great health, so we don't know.
Yeah.
That's funny. That's funny.
Miami, were you trying to say something? I think I saw, but you're muted, Miami. I'm sorry, Miami. Sorry, you're muted still. Let me see if I can unmute you. Hold on, you're still muted.
She's still muted.
Mute.
Okay,
Hi.
there you go.
That's it.
If I have if there's an irrevocable trust, and a whole estate planning was created, can you do a power of attorney and a healthcare proxy to at least cover the person, cover a human? The trust is mostly just a building, but the power of attorney and healthcare proxy is for the person who the trustee should care for. But so if you do a new one after the old trust and will and power of attorney, healthcare proxy, the new power of attorney and healthcare proxy will allow you to take care of the person as you've always have been.
Okay.
Do you understand me?
I think so. So let's assume mom still has capacity. And 10 years ago, she appointed daughter one to be, she created a trust, put all her assets in the trust, and appointed daughter one to be healthcare proxy power of attorney. They've had a falling out, and now she wants to appoint daughter two instead. So, yes, as long as mom has capacity and knows what she's signing, and daughter one can't legally, legitimately challenge it, then mom could do a new one and appoint someone power of attorney, healthcare proxy, etc. They are separate legal documents. So the trust and the trustee control whatever's in the trust, those assets. Power of attorney is for legal and financial decisions for the principal.
Yeah.
And the healthcare proxy is specifically for healthcare decisions.
Okay, that was important to understand.
Yeah, and it's a great question because Sometimes we put all the assets into the trust, then you have power of attorney. The power of attorney can't actually control anything. I mean,
No.
they can make legal decisions for the individual, but all the assets are already in control of the trustee.
Okay. I have another question, but I'll ask you on a separate note, or we'll make an appointment.
Okay.
Thank
Yeah.
you.
You're welcome. And I'll put my stuff in the chat as well.
Is it done yet?
All right. Any other questions from anybody? I don't think so. So I think I will just put my info.
Thank you. You ladies been helpful.
Yes,
A lot
glad you
going.
enjoyed
Thank
it.
you. Great questions. Great stuff.
Thank you.
Yes, thank you all.
This is all important stuff that everyone should really,
No,
Yeah.
they
understand.
have to look at their stuff.
Very good
Stuff.
note of and action is very key.
Right.
Yeah.
All right. Good night, everyone.
Yes.
All right, thank you.
Bye.
All right. So I'm going to stop recording. I'll hang on.